Welcome to the Thinking Legal podcast with me, David Koehne. This is a podcast about the human and psychological aspects of the legal sector. I run The Marketing Legal, a legal marketing agency, and you can find us at www.themarketinglegal.com. I hope you enjoy the show. Hi everyone, welcome to the podcast, and today I'm joined by John Meixner, who's Assistant Professor of Law at the University of Georgia, and he focuses on the intersection between law and neuroscience, which is particularly interesting, and he has an interest in criminal law. So John, welcome to the podcast.
Thanks for having me on, David. I appreciate it.
Excellent. And to start off with, do you think you could maybe tell me a bit about your background and how you came to focus on criminal law and how you entered academia?
Yeah, it's a little bit of a meandering story in some ways. I was a psychology major as an undergrad at the University of Michigan. Was interested in kind of a wide variety of sort of neuroscience-based aspects of psychology, especially about understanding how learning and memory work. And I was applying to graduate school as a PhD student to a bunch of various different programs across the country. And there was one person in particular at Northwestern University who was doing really interesting work trying to understand the neuroscience behind a deception and brain function occurs during times that people are lying and how to identify memory detection and things like that. I was really interested in the work, really enjoyed it. And then very serendipitously, when I was going through the interview process, I learned that Northwestern has a joint degree program where you can pursue a PhD in any department and then also a JD at the same time, designed mostly for people who have research interests that cross across both law and some interdisciplinary line, like economics or philosophy, or in my case, psychology. And it was a really perfect fit. I was interested in that sort of memory detection and deception research that I was talking about. I was interested right away in sort of how courts might think about that kind of work and how courts might confront new neurotechnologies and areas like that. So I applied for that program, got in, really enjoyed law school, and even beyond sort of law and psychology immediate issues, I really enjoyed a lot about legal theory, about thinking about how judges and other actors, especially in the criminal justice system, make decisions. There's an enormous amount of discretion in American criminal justice, at least, and so decision-making by folks like judges and prosecutors and police officers plays a major role in how the system runs. So I was interested in those sorts of things also quite a bit. So I did the joint degree and was planning on becoming an academic. And then I took a little bit of a detour. My wife was going to medical school. And so I was following her back to the University of Michigan where we did that. And while she was there for medical school and residency, I spent some time working for 1 year in a law firm, and then the rest of the time I worked as a federal prosecutor handling just about every kind of federal case you can think of, doing trials and arguing appeals. So I did that for about 6 years, and then moved back into the academy to think and write about a lot of these same things I've just described to you.
Brilliant. And you mentioned that part of your focus is on the psychology around decision making, and I understand that that's your kind of most current area of research too. So perhaps you could tell me a bit about your research into how judges come to decisions, and what's your findings?
Yeah, so right now I'm really interested in sentencing. So I spent a lot of time as a federal prosecutor handling sentencing hearings. And in the American federal system, it's a little bit unique in some ways in that judges often have a lot of discretion to sentence. So there's a set of possible sentences called the sentencing guideline range, which is a sort of starting point for judges to think about when deciding how to sentence somebody who's already been convicted or pleaded guilty to a crime. But then judges really are allowed to consider a sort of wide array of different factors, which I'll get into. I spent a lot of time doing that, and I realized it's a really important part of what criminal lawyers do, especially in the federal system, but also sometimes in state systems in the U.S. I also noticed some defense attorneys, I thought, did an excellent job at humanizing their clients and explaining sort of background characteristics and circumstances that had gotten them to the place where they were. Things like a history of a very underprivileged, impoverished upbringing, or a history of drug addiction or mental illness. These sorts of things seem to be relevant to a lot of the judges in deciding on a sentence. Some defense attorneys would emphasize those really, really clearly and well, in my view, at sentencing hearings, and some spent almost no time at all in that. And so I got really interested when I was just a practicing lawyer in how judges thought about those various different kinds of sentencing characteristics, what kinds of things they ought to be thinking about at sentencing. And so now I do a lot of work in that space, including one sort of long-term empirical project, which I can describe to you, or if you have a follow-up question to that, I'm happy to.
No, please do. But one thing I'd really like to know is that while you were a kind of federal prosecutor, were you aware of these were you aware of yourself being kind of influenced by these background histories?
Yeah, enormously. So another aspect of the federal system that's a little bit different sometimes than the state system is there's a little bit more time spent on each individual case because caseloads are lighter than they tend to be in the state system. And before sort of negotiating a plea agreement in some cases, I would sometimes have conversations with the defense attorney about background characteristics of the clients themselves. And so there were some cases where I had the chance to sit down with the attorney and have a long discussion about things about the defendant's background that might in some ways explain what happened or provide some context for what happened. To me, they were enormously important. So I certainly thought it was different when a defendant, for example, who had committed a robbery did so in part out of sort of extreme need and a lack of resources and opportunities from very early on in their life. One characteristic about the American criminal justice system, which is very unfortunate and problematic, is the vast majority of people who are prosecuted for many areas of crimes are relatively poor, often minority defendants, and there are many, many racial disparities throughout every aspect of the system. And so all of these things, in my mind, sort of connected. And so when I was a prosecutor, I often strongly considered sort of some of these background characteristics in thinking about how we ought to negotiate a plea bargain or try to resolve a case.
Yeah, and now maybe you could go into a little more depth about your current research then into this.
Yeah, so I wanted to try to find a way to study it a little bit more analytically. So, just anecdotally, I remember going to sentencing hearings and reading sentencing briefs and often thinking there's this wide array of mitigation that defense attorneys present, and it struck me as important. But anecdotes, can't tell you the full story about what's going on. And so I try to study things from a data-based perspective in a controlled way. And so what I do now is, in the federal system, attorneys typically file a brief just before sentencing called a sentencing memorandum or sometimes a sentencing brief. And what they do in that is the defense attorney makes arguments about why a sentence should be a particular sentence. So they'll advocate, say for a 2-year sentence as opposed to a 6-year sentence or whatever it might be. And in the brief, they'll describe why they think that's the correct sentence. Some of that relates to characteristics about the crime itself. So attorneys might argue the crime was actually relatively non-serious or non-violent or involved, less money than similar crimes or whatever it might be. Sometimes the briefs describe some of these sort of background circumstances we've been talking about. There's also a really interesting dichotomy in that judges have to look at a few different sources of law. So one of those is the federal sentencing guidelines, which for the most part tell them they shouldn't consider as relevant most of these background characteristics. So, a history of good character, for example, the guidelines tell the judge, you shouldn't really think about that, at least in deciding whether to sentence outside the guideline range. There's also a federal sentencing statute which tells judges to consider the history and characteristics of the defendant. It's the actual language of the statute. So it's very, very broad. And a judge might think almost anything qualifies as that. And so there's some sort of challenging sort of legal aspect to what judges ought to consider. So the way I tried to study this was I gathered a big sample of these sentencing briefs filed by defendants. And I and one other person coded all of the language, all of the words in the brief for various different categories of mitigation. So we might code the number of words that were devoted to, for example, talking about health-related mitigation, or about traumatic upbringing mitigation, or about mitigation about the offense itself, these various different categories. I did that, and I tried to examine basically how these different categories of mitigation correlate with the judge's sentencing decision after controlling for the severity of the crime and the sentencing guideline range. And eventually found that these sort of personal mitigating characteristics, as defense attorneys spend more time arguing about those in the brief, the sentence tends to be much lower, even controlling for the guideline range, whereas that same relationship doesn't seem to occur when they talk about mitigation about the offense itself.
Yes. And did you find any variation between the categories themselves?
Yes. So so using a technique called linear regression, you can try to control for various different things that might be affecting these outcomes, and essentially try to parse out which different characteristics of mitigation best predict reduced sentences. The ones that I found were the most predictive of lower sentences were health-related mitigation, which includes things like mental health or drug addiction, when it's supported by some kind of underlying evidence, like a diagnosis from a doctor or something like that. Also, mitigation related to someone's character, so showing that they have sort of a fulsome life apart from this particular offense, that they have other things about them that make up their character. And then also mitigation about collateral consequences, so arguments that incarcerating someone might harm their family members who might rely on them or might have a negative immigration context or things like that. So those three things all predicted reduced sentences more than any other category. Now, it's really hard to say whether that's causal, so it's a correlation. So we know when attorneys make more of those arguments, sentences tend to go down. What's causing that relationship could be things other than the arguments themselves, and that's a little bit hard to tease apart.
Yeah. And where do you see yourself taking? What are the next steps in the research?
Yeah, so I'm actually working on a follow-up project right now. So one of the big limitations of the project I just described to you is I gathered all the data from publicly available court records, essentially. And those court records contain almost no information about the demographics of individuals. And so in most areas of criminal justice, we see that there are enormous disparities, both along the lines of race and sometimes gender, and also economic status. And so it could be the case that mitigation only helps wealthier white defendants who have money to hire their own private attorney, or maybe at least disproportionately helps those folks. Or it could be the case that there's not a disparity like that. So what I'm trying to do now is I've gathered some additional data from the U.S. Sentencing Commission that maintains demographic data on everyone sentenced in the federal system. I reached an agreement with them to get those anonymous data just for the individuals in my data set so that I can control for those various different demographic factors and try to identify whether mitigation is something that tends to influence all cases equally, or whether there are sort of biases in the way that mitigation occurs during cases.
And at the beginning of the show, you mentioned that you're also interested in neurotechnologies, and let's move on to the kind of neuroscience side of your practice. So. Perhaps you could tell me a bit about kind of your kind of early research into that.
Yeah, and I'll just say sort of one way that this lines up or dovetails with the research I just described is that, as I'll say in a minute, neuroscience has the potential to sort of impact a huge variety of different types of evidence. So one of the types of mitigation I just talked about that I think is driving part of this effect is mitigation related to mental illness. And neuroscience-related data increasingly I think are going to be relevant in terms of diagnosing and understanding mental illness in a different way. And so I think what we think and learn about neuroscience, courts will have to confront sort of how to think about some of these things as we learn more about the brain structure and function that ultimately drives things like mental illness. But to answer your question a little bit more directly, so when I was a graduate student, I spent some time working on this paradigm called the concealed information test. And it's sometimes likened to a lie detector, but it's actually a little bit different. And the basic idea of the test is that it's trying to identify when someone recognizes information that might be relevant to the commission of a crime or some other kind of event. And I think the easiest way to understand it is to take an example. So imagine, David, you had committed a murder using a .357 revolver, and somebody was trying to determine whether or not you were involved with that murder. The idea of the concealed information test is you could take you and several other suspects who had no idea about how the crime occurred or what happened with it, and you could show each person a series of different weapons, for example. So, you know, the revolver we're talking about, and a candlestick, and a lead pipe, and a knife, all these different things. To someone who is totally non-knowledgeable about how this murder happened, each one of those items will be equally meaningful to them. They'll appear the same. But to you, when you see the revolver that you used to commit the murder, you would recognize that as meaningful. It would stand out to you in your mind. And there's a way you can try to measure information or stimuli that are meaningful like that by measuring electrical activity at the scalp using electroencephalograms, so EEG or ERPs they're referred to. And the idea is there's this brainwave called a P300 that's very large when someone sees a meaningful item among a list of non-meaningful, irrelevant items. And so the idea is when you recognize that revolver, you would have a large P300 wave in response to that one compared to the others, and that could be detectable in some way. And in lab contexts, it actually works quite well in detecting various different kinds of information. So one project I did in graduate school was I had people wear a body camera around during their everyday lives, and I tried to see if you could detect various different bits of information they had just acquired in everyday life, like which grocery store among this list did you go to, or what class did you go to during the middle of the day. And it turns out you can identify those things pretty well. So some of the things that I write about and work on are asking how courts should deal with emerging neurotechnologies like that. So police forces in the United States don't currently use the concealed information test, but some other countries do. So Israel and Japan both use some variant of it in routine police practice. And so I write sometimes about how courts ought to think about confronting that kind of technology. I think there are some benefits and obviously some drawbacks to using that sort of thing. One benefit in that particular context is the polygraph or the lie detection paradigm is still regularly used by police departments, probation and parole officers, usually not as evidence to try to prove a crime, but it might be used in other kinds of investigative techniques. And it's probably pretty problematic in a lot of different ways. It's not a very accurate test. And so part of the idea is some of these technologies might be able to replace even more problematic versions of them.
Yeah. Why do you think the polygraph is still used?
Mostly because it involves a sort of interrogation process, and that can be useful to police for getting confessions. It's very controversial on that point. In my view, I don't think it's a very legitimate practice, and we probably shouldn't be using it. Sometimes the actual outcome of polygraphs can be used in very limited legal proceedings. So in some circumstances, for example, somebody who's on supervision following release from incarceration might be obligated to take a polygraph as part of the conditions of their supervision. And if they fail that, if it determines they're being misleading to a parole agent, for example, that can be problematic for them. I think that also is maybe even more troubling than the former, especially because these tests are just extremely unreliable. They have a very high false positive rate.
So it's more part of the theater of the process.
I think that's right. Yep. And so part of the work that I was working on, I think, is trying to find a way that's a little bit more scientifically valid. I think there are very serious concerns with trying to admit any kind of neuroscience-based recognition detection, as I've explained also. There are sort of very complicated questions about individuals' right against self-incrimination, or even sort of our knowledge about the long-term reliability of the test. So I think it's certainly not ready at that stage now, but I think at least worth studying and trying to think about how courts ought to handle these sorts of things when they're confronted with them down the road.
Yeah, and can the other technology, can it the P300, can it detect if someone recognizes an abstract concept such as a date or something that isn't a physical object?
Yes, it can. So it can work on various different kinds of stimuli. So actually, one of the most prominent ways that people study it is by using various different dates on the screen. And if one of those dates is meaningful to you, for example, your own birth date, you'll have a large P300 response to that meaningful date as compared to a bunch of irrelevant dates that you also see alongside of it.
So you mentioned that the kind of part of your work was to kind of consider kind of how it can be implemented in the court system. How do you think it should be used, bearing in mind the kind of ethical considerations around it?
Yeah, I think we don't know right now, because one of the biggest problems is it's mostly been studied in the laboratory context and not in the real world. So it's easy sometimes to identify salient information. Like one way people study this kind of paradigm in the lab is they'll have someone commit a mock crime. They'll go tell them to steal an item out of a box in the next room, come back, they steal, for example, a ring, and then the experimenter tries to see if they can detect recognition of the word ring among a bunch of other items. That's very different than someone who's committing a crime, for example, in the real world and acquiring some information about that crime. There's not a whole lot of research about the test's sort of efficiency, its accuracy in the real world. And so I think right now it's still sort of too preliminary to know how it might be useful downstream. And I certainly think there would be serious problems with ever trying to compel someone to taking that sort of test. And so I think there's a number of hurdles before it ever could be something that's really plausible in the courtroom.
Yeah. So you mentioned that kind of another aspect of your work deals with kind of mental health, and perhaps you could kind of round the discussion off with talking about that.
Yeah, of course. So one of the things I'm really interested in, going back to the sentencing concepts that we were talking about earlier, is when I was trying to identify different categories of mitigation, one of them that I coded for in that earlier study was mitigation about someone's health. And I coded that as a really broad category because it's kind of hard sometimes to parse out different arguments about someone's health. But it included things like mental illness, like schizophrenia or personality disorders. It included things like a history of drug addiction, and also physical health, like somebody who might physically struggle while incarcerated because of an actual physical, non-mental injury. I coded all of those things collectively together. And so one challenge of that is I can't really tell to what extent health-related mitigation is driven by mitigation about mental illness versus physical illness versus drug addiction. So part of the long-term project is to try to more deeply dive down specifically on those individual things. I suspect, and again, I don't have data to support this yet, I suspect that arguments about mental health drive a lot of what I found in my original data. I think because judges are often trying to sort of discern the extent to which individuals are making sort of very free and deliberate choices about crime versus things that are in part driven by things outside of their own personal control, like mental illness. I think that's driving a lot of the sort of mitigation findings from that study. And so I'm hoping I'll be able to gather a large enough sample of sentencing memoranda that discuss mental health specifically and try to understand a little bit more clearly what kinds of mental health mitigation are persuasive and relate with lower sentences.
Thank you very much, John. That was a really interesting conversation, and it sounds like your research is really important in the US context, and I guess kind of has potential to kind of impact kind of other jurisdictions as well. So thank you very much for sharing your knowledge today.
Thanks, David. I appreciate it. Thanks for having me.